Welcome to Employment Law This Week. I'm George Whipple. The NLRB has kicked into high gear as of late with a series of decisions reversing long-standing precedents with a focus on non-union workplaces as well as those with unions. Last week, we updated you on the board's restrictions on severance agreements. This week, we zoom out to examine how several recent pronouncements and actions by the board and the agency's general counsel's office are creating new challenges for employers, both union and non-union. And here to help us do just that are Epstein, Becker, Green, Steve Swirsky, and Neresa Biasi.
From the start of this general counsel's appointment, and as the board has transitioned to a Democrat majority appointed by President Biden, the overall philosophy has essentially been to undo everything that the board did during the Trump administration and to continue to move towards a much broader set of employee rights and restrictions on employer activity, many of which are totally inconsistent with longstanding precedent.
This board and general counsel have tried to make it a lot easier for unions to organize workforces. They've also provided a lot more leverage to unions during negotiations. They've also tried to give unions much more access to employer workforces and to employer information. This board and general counsel have tried to expand the scope of the act to non-union employees and non-union workforces as well.
The general counsel and the board have both made very clear that the act applies in all workplaces where there are statutory employees, not just workplaces where there are unions or where organizing is taking place. They have engaged in a campaign to educate employees on those rights. Last week, the general counsel announced the initiation of something called Know Your Rights cards for all employees to keep in their wallets or their purses to refer to explain what their rights under the law are under the act. The board has also issued decisions concerning things such as confidentiality, non-disparagement, and the like that apply equally in non-union workplaces.
Previously, there wasn't so much of a focus on the actions of non-union employees at non-union workplaces being protected under the act. But now the general counsel and the board are trying to find that protected concerted activity exists at non-union workplaces. And they've also expanded the scope of what protected concerted activity may be by introducing a category of inherently protected activity. This board has made it a lot easier for unions to access workplaces and, again, has really promoted union organization. So that's concerning to employers who have never faced a union organizing campaign before, who do not have unionized employees.
Thanks, Steve and Neresa, and thank you very much for watching. We'll see you next time.